than any of the departments of the executive department.
The judiciary, the Supreme Court, is a co-equal branch.
Yeah, insofar as the departments are concerned, right?
Yes, Your Honor.
But how? I'm referring to the other cabinet, cabinet of the president. Are they, or the departments under the president? Are they co-equal with the? Is that what you wanted to tell us?
Well, the departments or the executive offices under the office of the president, they all form part of the executive department.
Correct.
So they have the executive department, all executive officers have their respective powers and prerogatives in the exercise of the executive power, and the executive branch of government happens to be a co-equal branch of government.
And in the distribution of powers under the Constitution, it is not the cabinet member or the department officials that are on level with the judiciary, is it not?
Well,
it is the president or the chief executive.
The officers under the executive department, or specifically the cabinet secretaries, they are considered the alter egos
Right.
of the president.
Right. Now, if that is so, why could there be a dispute relative to the validity of the resolution of the Honorable Supreme Court in connection with the issuance of hold order by a secretary of the secretary of the president?
There is an issue because of the propriety of the TRO. As I explained earlier, responding to the question of the Honorable Presiding Officer, we are questioning the propriety of the TRO because it violates, or it went against, or goes against the very essence of a TRO.
And after your challenge against the TRO had been resolved, is there any alternative left to any member of the cabinet to disobey the order or ruling of the Supreme Court, irrespective of the nobility of purpose on the part of the secretary?
Yes, if there is a final ruling on the issue of the validity of the TRO, then we will have no choice but to adhere to the TRO, because that would be a final ruling of the Supreme Court, and we cannot reverse the Supreme Court on that matter.
I understand that in this case there was a ruling already insofar as the TRO is concerned, is it not?
Yes, Your Honor, that was November 18.
Yes, and that had never been amended, much less repealed or revoked as of this time, is it not?
No, Your Honor, because it denied precisely the motion to lift and or motion for reconsideration of the November 15, 2011 TRO.
And the motion to lift was denied.
The motion to lift was denied in the resolution of November 18.
And it means, to us, it means therefore that the TRO stands as it is.
As of November 18, it was not yet clear because of the dispute on the exact interpretation, the import of the TRO, whether it was already considered effective on account of the non-compliance by petitioners with condition number 2. Nalaman po natin.
Is that, I'm sorry, Mr. Madam Secretary. Go ahead, please.
As of November 18, hindi pa ho klaro yon na effective na yung TRO. Wala pa nga ho silang pinalabas any confirmation, any order, any ruling na yes, there had been compliance already with the conditions of the TRO. Sa pagkakaalam ko po, kailangan ng separate order or any clarification from the Supreme Court doon sa compliance. And it is only when there has been a confirmation of the full compliance with the conditions na pwede na nating sabihin na naging effective na po yung TRO.
I know that you had been a practitioner of note before entering the government. Is that right?
Yes, Your Honor.
All right. And you must have been continuously in appellate practice.
Well, I have some exposure to appellate practice.
Yeah. And you knew that the Supreme Court acts in banc and also in a division.
Yes po.
And
Yes,
the
sir.
decisions of the court, Supreme Court, whether in bank or in division, must be a majority decision.
Yes, sir.
It is in its entirety, it is the responsibility of all the members who participated therein, not a particular member, not even solely by the ponente.
Yes, sir.
All right. Now, in this particular instance, there is a statement in here, and may I be allowed to read it for your benefit? Respondent betrayed public trust through his partiality in granting a temporary restraining order in favor of former President Gloria Macapagal Arroyo. My understanding of this particular impeachment article is that it was the Honorable Chief Corona who issued the restraining order. Is that correct? Or do you agree with that, based on the allegation of this impeachment complaint?
Well, as crafted,
So-
it seems to be the connotation, but it's actually referring to the TRO as issued.
Yes. And in that particular TRO issued was not solely issued only by the Chief Justice. In fact, he has no participation in the issuance thereof.
Well, he concurred in the issuance of the TRO because he was one of the 8 members
So
who voted in favor of the issuance of the TRO in November 15.
Why could you give us an explanation as to why the charges were merely leveled against the Chief Justice, notwithstanding the fact that there would have been no TRO had there been no concurrence of the majority of the court?
Well, the allegation is with respect to partiality. Now, betrayal of public trust because of the partiality on the part of the respondent in issuing the TRO, which had the effect of aiding the former president to leave the country and escape prosecution
No,
or
I
escape.
have not gone that far yet. My only question is, since this TRO, according to you, was granted by the Supreme Court, acting in bank, and there were 8 justices who participated therein. In fact, there is an allegation that the rest of the other members of the Supreme Court conspired and confederated with the Chief Justice in issuing this TRO. Do you subscribe to that view, or may we hear your comment in connection therewith?
Objection, Mr. President.
What is
Question
the
is
basis
misleading.
of, what's the basis of,
There's no admission.
what is the
there's no-
basis of the objection?
Yes, the question is predicated on the
I was
claim that there is conspiracy among the
Well, a while
the
ago,
justices. Yes.
Your Honor, please.
So I object to that because there's no such allegation.
I'm not
in
saying
the
it.
complaint of conspiracy, nor is there any statement by the witness, but that there was conspiracy.
I have not gone that far, Your Honor. I just predicated my question on your admission to the question, to the clarificatory questions made by the Honorable Senator a while ago, that the 8 or the other members conspired with the Chief Justice that enabled the Chief Justice to issue this alleged or questionable restraining
So
order.
the question, Mr. President, I understand therefore that the question is hypothetical. In other words,
Oh no,
because there's no admission
We
of
submit, Your
conspiracy
Honor.
here.
Wait a minute. The question is, did the counsel for the member of the prosecution asserted that the respondent conspired with other members of the court to issue the TRO? Is that
that question. Yes,